Oh, loud.
All right. Well, we're at 1 minute past the hour. I think we'll give it a couple more minutes as I see a few people.
No, you're unmuted.
No, we're speaking live
Oh,
from Jan's laptop.
oh.
We'll give it a couple of minutes for a few more people to slide in from the waiting room. While we wait for them, I'll start us off with an introduction that barely does Jan Pederson the slightest bit of justice. But those of you who know her will know that she is famous as the godmother, perhaps the midwife, but certainly the drafter of numerous J-1 physician category terms, having worked on the statutory category for decades. She was key to drafting the J-1 physician legislation that established the waiver program over 3 decades ago, and she has been tireless in her ongoing support of thousands of foreign physicians and hundreds of their employers in the US in the decades since then. Now, Attorney Pederson's professional awards and accolades include a Lifetime Achievement Award from the International Medical Graduates Task Force, which is a vital J-1 physician advocacy group. And she has been recognized by the Washington Post, a nationwide paper, as one of the 7 best lawyers of all specialties in Washington, D.C., out of a total census of 80,000 plus. With Jan Pederson, you get all-round comprehensive immigration law coverage. Her experience spans J-1 waivers, H-1B work permits, and green card processes. She is also a recognized leading expert in consular processing of visas overseas at multiple posts, with experience editing the consular processing handbook to teach the craft to other lawyers. I believe you've just put your finishing touches on this year's
Yes.
edition of that. Many bloodstains and tears going into that at late hours. Her other publications include The Definitive Guide to the J-1 Physician Waiver Process, now available to you on wcslaw.com. We are privileged to have so much knowledge in one person here with us today. Not only did she help draft the law in the first place, but she's available to help you through your process with her many years of experience. Now, just the usual legal disclaimer, as we're all lawyers. Today's presentation is for informational purposes only. It does not constitute legal advice, and it does not create or establish an attorney-client privilege relationship. Please make sure to visit wcslaw.com and pick up a copy of the guide for J-1 physicians, employers, and recruiters. And with that, I think we're good to go.
Thank you, Ben. And welcome to all our participants today, particularly J-1 physicians. I see we have some people from the State 30 Conrad programs here, and all are welcome. I want you to know that this seminar is for you, the J-1 physicians. It's yours. Take it over. Ask any questions that you want. There are no such thing as a dumb question. We're here to answer them, and we're available to represent all J-1 physicians in all their immigration needs. Um, as you may have noticed, we now live in a topsy-turvy 1000% uncertain world. So
I believe the term is high adaptability environment.
there are other words for it. Ben, yeah, we have a lot of change now. You all have not been terribly impacted, but we're going to go through some important items that you need to be aware of. And all right, so today, being a non-immigrant in America, there's some things that concern you. We haven't covered those which generally don't apply to our physicians. Okay, remember that no one, and I mean no one, is immune from questioning by USCIS or ICE. Know your rights and enforce those rights and practice those rights. Um, Today is a bit on steroids, but it's not dissimilar to what was going on after 9/11 when the government required all males of a certain age from, I believe, 24 countries to report. Many of you may be too young to remember that. We remember that. So know your rights. Do not be afraid. When ICE comes knocking at your door, call your lawyer. Just memorize that. Teach it to your spouse, your children. You don't have your 9-year-old just being friendly and opening a door. Okay, you do not have to let them in unless they have a search warrant issued by a court. The common one that you see is called an ICE warrant. That you do not have to let them in. If they come, close the door and go outside and talk to them. And I know that sounds okay for me to say. I'm an American, I'm a lawyer, I'm fearless. And I say, don't you dare come past that doorstep. Okay, we know the fear factor is prevalent and endemic in the community today. So practice that. Your best thing is to have your lawyer's phone number memorized, have the card in your pocket, have a letter from your lawyer saying that your lawyer is your lawyer. Any issues, they're not allowed to talk to you, they're to call the lawyer. That will give you some sort of level of courage. Do not drag out all your immigration documents and show them. Just say, I'm a foreigner in this country. I'm unfamiliar with the laws. I don't know what's going on. Please call my lawyer. Take out that card and hand it to the lawyer. I mean, to the ICE guy. And unlike you see on TV, there are nasty ones, but there are also very nice ones. Really, I can say after many decades of practice, they're basically nice. Now, if their bosses are telling them to do something that's immoral, wrong, or illegal, or they lose their job, that's really an area where we are now. So we put on the slide there, a contact for Know Your Rights.
That's the National Immigration Law Center, NILC. Well worth looking that up. Save them as PDF, keep them with you, read them, and understand them.
Always carry proof of your legal status with you. That is not a new law, but it's newly enforced. So you can be arrested if you don't have proof of legal status until it can be found, hopefully only until you can be found. In your cases, that would be DS 2019, H-1B approval notices. I-94 is very important, and government ID. And failure to do so can result in both civil and criminal penalties. This actually dates back to after World War II. Never in my life enforced until now. We have had reports of some arrests in various states for failing to carry proof of legal status.
And for the Form I-94, each passport holder, each foreign passport holder can also log on. If you just Google I-94 form online, you can find the government site to obtain your own. Make sure to check those details against the last time that you entered the US. Make sure they're consistent. If not, talk to your lawyer and that can be corrected fairly straightforwardly.
Yeah, and the next question is, well, what about my 6-year-old going to school? What do I have to tell my 6-year-old or my 8-year-old? We the neck bags that children carry onto airplanes when they travel, are they
Neck
real
wallets.
neck wallets? Are they really going to have to carry that with them around their neck with their proof of legal status? I don't think it's absurd to say that they should. Uh, you'll handle that as a parent in terms your child can understand without hopefully too much fear. Okay, this is one that we found that our physician clients may want to immediately comply with. You are required to change your address within 10 days of moving. If you have omitted to do so, especially this time of year when people are getting ready to move to go to waiver jobs or new uh, residency or fellowship programs, and failure to do so can incur civil and criminal penalties.
And that's the Form AR11, Alpha Romeo 11. If you do a quick Google search, change AR11 online, you should find USCIS pages that will help you do so on your own. It's very simple. So far,
Yes,
USCIS
and it's
is,
done through your USCIS
yes.
account. If you don't have one, make one for every member, an individual one for every member of your family.
Okay. Next slide.
Okay, now the registration requirement. We have as many questions about that as about carrying proof of legal status with you. Uh, so there's a registration requirement for all non-citizens as of April 11th, 2025. And again, obviously it's a terrible invasion of your privacy, and it's more and more and more and more data you're giving to the government. There is a criminal penalty for failure to register. Most of you all are registered. I think our main issue here are Canadian citizens and children. So children over 14 have to register within 30 days of their 14th birthday. Well, you logically say, well, what do I do if my child came in when they were 12 and now they're 15? They haven't registered within 30 days of their 14th birthday because it wasn't enforced. Register them now. There are a lot of questions about children's and Canadians. Just let us know in the chat box if you have a question. Okay, those who are considered to be registered, I think we've had somewhat over 80 or 90 calls about that. So you're registered. You're already registered if in the following situations. If you have a green card, if you were granted some sort of parole into the United States, such as United for Ukraine or any of the other programs, if you were admitted on an immigrant or a non-immigrant visa, even if expired. Now, again, the 14-year-old cutoff that has to register. The 14-year-old situation has been the debate of about 90,000 emails among immigration lawyers. What does that mean? Okay, this doesn't apply to most of you. If you are or were in removal proceedings, you are registered. If you've been granted employment authorization, even expired. Refugees and people who applied for permanent residence, even if denied. And then border crossing cards, those are for Canadian, for Mexicans. Next, so that's who has to be registered. Okay, so that's your 30 days of turning 14. Got to create the CIS account online and completing Form G325R. Again, every member of the family who is a non-citizen needs an account, and carry the registration with you. Next. Okay, that's enough of scary stuff. Um, what I want to say before we get to substantive waivers, issues, and the options if you didn't get one this year are travel. I would say about 80% of our calls from our clients regarding travel. No immigration lawyer in their right mind would say it's okay for you to travel. If for no other reason that it opens us up to malpractice suits if you travel and you have a problem. So please do not expect us or any other lawyer to say it's okay, because it's not. You don't know when your number is going to come up. You don't know when you're going to be harassed. So then we get clients say, well, I really got to travel. It's a really urgent thing. Then we tell you, well, would what is your career worth to you versus why you were traveling? Uh, you know, you have to weigh that. It's your personal decision whether to travel. Now, if despite being cajoled, warned, threatened by your lawyer not to travel, you decide to anyway, what you need to do to be extra cautious. Remember, lawyers are talking in worst case scenario, all right? Worst case scenario, you get stopped on your way back to the US, detained by ICE, shipped off to somewhere. First, you're detained by CBP, turned over to ICE, and shipped to, you've heard all the stories, God forbid, Texas, God forbid, Louisiana, and then we don't know what happens to you. So if you want to ensure that you will have maximum coverage if there is a problem, then you want to consider what airport you're coming to. And you will never want to go to most airports, no Chicago, no Detroit, no Texas, no California. Probably you will get the best shot at JFK. So change your plans and enter in JFK. Then you want to have a lawyer on standby because, as you know from the media, they are moving people in the flash of an eye. And if you don't have your lawyer down at the courthouse, where at the airport where they detained you, they might never find you again. As you know, this is going on a huge level. It's been well publicized. And don't say, well, that isn't me. I didn't do anything. I've never done anything wrong. I don't have any social media posts. I've never said anything that could be remotely considered pro-Palestinian, so they're not going to touch me. Don't assume that. So what you want to do is have a lawyer on standby, know your travel plans, and then call your lawyer if there's a problem at CBP in the airport. Now, what's the catch-22 there? You're not allowed to use your cell phone in the primary or secondary inspection areas of customs. So what do? You have a number on your cell phone pre-programmed to call. We used to call them speed dial. I don't know what we call them.
They're still speed dial.
Speed dial. All right. Then you go have a relative, probably a relative, just in case your lawyer isn't at their cell phone at that moment. Call your designated person, tell them you have a problem, move on, and go in the bathroom. You say, I have to go to the bathroom, go in the bathroom stall, make your call. That may be the only chance you have. And you may want to retain a lawyer to be on standby for that trip that you're taking. Also, you know that there's been a pandemic of student visa revocations. There's been over 1,500, probably more, challenged in court. So that the equivalent would be, for example, if a J-1 visa is revoked, some of those have been revoked, but the massive number have been students. So it could spread to J revocations without your knowledge. So enough of that terrible news. Let's talk about good news. There are plenty of waivers available still. It's not too late. The first thing we would advise you is if you're going to finish in June of 25, and of course, you're just in the right time if you're finishing your training in June of 26. So you got plenty of time. Always extend your DS 2019 to take a board exam if possible to cover unforeseen contingencies. And what we can say about what is going to happen in your world, in our world with you as we journey through the J-1 waiver, H-1B, and green card, is everything is going to slow down. As if it wasn't slow enough before, it's going to be worse. They are going to they have already started taking biometrics for H1s, even though they have the biometrics. That'll slow the process down. They are requiring in-person interviews again. As you may know, during the last few years, most green card interviews in person have been waived, and the cases have been approved on paper. So that will slow down the green card process. So everything is going to be slow. If you decide to go to a consular post, as you know, they're slashing personnel, already closed a number of embassies and consulates. So yeah, it's delay time. So now to our substance here. Remember, HHS, ARC, DRA, and the VA give an unlimited number of waivers and are open year round and cover large areas of America.
So these are all the federal agencies. So these
Yes.
are the federal governmental level, not the
And we
states.
have two others that didn't get on the slide. We have the Southeast Crescent Regional Commission, which covers all of Florida, good part of Georgia, even the Southeast Crescent Regional Commission has areas of the state of Virginia that are covered. In Northern Virginia, I don't know how that worked out, but they will give waivers there. They're still open and take advantage of them. So, next. Okay, so if a waiver isn't available to you this year and you're going to finish this year, here's some options for you to consider. We have our Canadian citizen bonanza. We have, I'll get into the substance of those. We have E3 visas for Australian citizens. We have E2 treaty investor spouses. We have temporary protected status for many countries. We have physician national interest petitions known as PNIWs. They're an I-140 petition. for I-140 base green card application. We have persecution waivers. We have hardship waivers. We have political asylum. So we have a whole panoply of alternatives for you. O1 and O1s, of course. Okay, so our Canadian citizen exception. Canadian citizens can obtain H-1B status without obtaining a J-1 waiver. Again, without obtaining a J-1 waiver. However, you have to eventually get a J-1 waiver if you wish to get a green card. Now, the caveat with that, where there's a long line or there are delays or you found a job at the last minute, well, you can do that H-1B without the waiver. And maybe you want to miss the waiver this year, you love the job, so you're going to try again next year. Now, two caveats on that is the employer must be exempt from the H-1B cap. Who is exempt? Just this is broadly, there are a lot of exceptions. So in other words, if you got a J-1 waiver, the cap goes on you and you carry the cap exemption with you. Okay, if you go use the Canadian exception, you don't have your own waiver. It has to be the employer being cap exempt to employ you. The first one is a very common one. It's used by hospitalist companies. It's used by universities, nonprofit hospitals with affiliations. It's called the by-ad exception. You can be employed by a for-profit entity to work at a nonprofit hospital affiliated with a public or nonprofit institution of higher education. So those would be people, hospitalists, and people employed by staffing companies. One caveat there, and we just had this come up. We had a hospital with a saint's name, whatever, St. Francis, yeah, that would be good one, St. Francis. So who would think that St. Francis is not a nonprofit hospital? Well, just double checking, they were bought by a huge national for-profit, so they can no longer help with this by-ad exemption and some research institutions. Now, one of my favorite, which I was actually very happy to negotiate back in the 90s, another Canadian benefits is sleeping in Canada rule. If you sleep in if your country of return is Canada, regardless of your citizenship, sleeping in Canada and the only activity in the United States is employment. You can fulfill the 2-year home residency requirement by sleeping in Canada for 2 years. If you're interested in that, we'd be happy to talk about it. You've got to obviously document that you have everything in Canada except your job. Okay, our next exception. Okay, every year there's some who come to us who are citizens of Australia. Do not have to be born in Australia, just be a citizen. You can obtain an E3 visa to work in the United States without a waiver. No employer petition required, valid for 2 years with unlimited extension, and of course, no J-1 waiver required. Again, with all these exceptions, you have to eventually get a J-1 waiver to get a green card and most other things. So the one point you might want to look in is the labor condition application is required like it is for the H-1B. And the employer, that's really the only proactive thing they have to do is file a labor condition application for the prevailing wage.
So this E3 for Australians is similar to the H-1B for Canadians. To enter the E3 or to enter the H-1B, you don't need a J-1, but if you want to exit it into a green card track, you must first get the J-1 waiver.
Yes, somewhere along the way, yes. Next. Okay, this has been a time-honored option when you don't get the waiver you want. It has become less useful. PNIW is a self-petition in the employment-based second preference category filed on a Form I-140. You file it for yourself. It's available regardless of your prior visa status, J, F, H, whatever. You must agree to work for 5 years in a medically underserved area or areas. The 5 years need not be consecutive, but can be completed with no time limitation. That is valuable for those who want to do fellowships after completing the J-1 waiver time. So the thing to know about that is historically, when you couldn't get the waiver, we would say, okay, let's file a PNIW I-140 and the green card application together with the application for a work permit and travel document. That was valid until 2023, I believe, a couple years ago, because the employment-based second preference was current. It is no longer current for anywhere in the world. It is about 2 years behind for the rest of the world except India and China. So the value of a PNIW has lessened because you can't get the work permit. So if you can do it early enough in your training, your priority date, your place in the green card line may be current by the time that you need to have that to start work in your post-training job.
Does the PNIW approval, even if you're then blocked by a waiting list, but you have the approval in hand, does that still let you extend the H's beyond 6 years?
Right. The value of any approved I-140 is that an H-4 spouse can get employment authorization, and it waives the 6-year limit on H-1B status indefinitely.
And that also applies to our Canadian friends who might be doing H1s and they get close to the end, they could have an I-140
Oh, our
approval.
Canadians can do all that. Yeah. Yeah. We thought they were our country's best friends till recently, but anyway, next. So the PNIW, very important to remember, it can be filed prior to the commencement of work in a medically underserved area and before a J-1 waiver is approved. Prior to, so you can file if you're in your second year and you have a job and you can get a contract, then you can file a PNIW. Okay, as we said, there's a backlog in the EB2 category for planning purposes. No waiver, J-1 waivers needed, but needed to have file a green card application. That's your other work. That's one workaround. Next. TPS has become in everyday lexicon. TPS stands for Temporary Protected Status, just briefly, of the Attorney General of the United States, designates countries we deem to be unsafe for its citizens to return, and the countries are listed and are available. I encourage everybody to get TPS if they can. If you're from an eligible country, it can run parallel to other immigration statuses as well, such as J-1, F-1, H-1B. There's a general saying: if an immigration is benefit is available today, don't wait till tomorrow. Go for it. Get the EAD. As you've heard, I'm sure the current administration is trying to withdraw TPS from many countries. There's litigation in courts, there's injunctions. So far, we're doing very well on enjoining that. But should you do it? Yes. Um, a
And
lot Lebanese doctors are included. The TPS list, if you just want to Google TPS countries, and each has various regulations: when to register, when to re-register, when you had to be here. So lots of Syrian doctors, wise Syrians, Lebanese, and many more.
yeah.
Huh?
And it's important to note
Specialist
that
countries.
TPS is on top of the others. So if you have a J1, you can't hold an F1. If you have an F1, you can't hold an H1B, but you can hold any one of those lettered
Parallel
categories
with
and have a
TPS,
TPS on
parallel.
top of that. Yeah.
Okay, so TPS is, a lot of people have resisted doing it. I don't know why. I mean, even before January 20th. So I would say if it's there for you, you should probably, there probably wouldn't be many circumstances when you should, when you would not get it. It makes you more employable, just as being a Canadian citizen makes you more employable. You got TPS, so I can start work and then we can worry about waivers. Now, with TPS, you're still going to need a waiver. So eventually you'll need a J-1 waiver, but it's a good alternative if you're from an eligible country. Okay, go ahead. Back, I'm sorry, back. Okay.
So
Now, there are a lot of questions that come up about changing to and from TPS. If you've been in status before you get TPS, you can then change to another non-immigrant status. So let's say you went J-1, you're always in status. You filed for TPS while you were still in valid J-1 status. You got TPS status, and then you wanted to get H-1B status, you may change to other statuses in most cases if there was no status gap. Okay, the next one, options. Okay, so we're going to focus now on alternative waivers, um, hardship and persecution. Okay, they're both, hardship and persecution have a lot of similarities. Um, They're all filed on an I-612 application filed with USCIS. USCIS then makes a recommendation and sends it to the Department of State for final approval. Very few are denied by the State Department if they're approved for recommended by USCIS. For a hardship waiver, you need an anchor relative. You must show exceptional hardship to an American citizen or permanent resident, spouse, or child. You must show two separate hardships. Hardship if the U.S. citizen or permanent resident, spouse, or child stays in the U.S. and the J-1 goes home, and also if the U.S. citizen or permanent resident go home with the J-1 for 2 years. So let's focus on some more things. The next question would be, what is hardship? Is my hardship enough? So processing time is long, so you can even start in your first year of training if you wish. Processing time is something around 12 to 14 months, so you need to plan for that. Of course, they're limited in number and available throughout your training. Beware of your J-1 sponsorship ending if the hardship waiver is granted too early and you still have part of your J-1 training to complete. That could be a problem, so you want to be aware of the timing. The other item is that you must leave the U.S. and obtain an H-1B visa with the H-1 cap exempt employer if you go to H-1 as a bridging status until you get permanent resident either through a spouse. So now we'll talk about some of the elements quickly. We want to take your questions. We've got a lot of them here. Remember that if the Department of State denies your hardship or persecution waiver, USCIS cannot approve it.
but
However,
that's rare though, right?
very rare. There's almost 100% approval rate for both hardship and persecution waivers. So really, it's a question of how early can you get it in to make sure you get there on not too late and not too early. Okay, when you talk about hardship, it's not even mentioned anywhere in the regulations, but a huge consideration, and then probably the most important one is the country conditions. What country are you taking your qualifying U.S. citizen or permanent resident, spouse, or child back to? For example, we're probably not going to make you go to Syria, Iran, or Pakistan, or any other country in turmoil, not to Ukraine, not Venezuela. So some countries that can be assumed. Then you have a lot of medical, they give a lot of weight to medical conditions, especially in children, physical, mental, emotional disabilities. One thing that's often overlooked is career destruction or disruption. So if the qualifying U.S. citizen or permanent spouse were to lose their career, not just a job, but their career for some reason, if they went with you, that's given quite a bit of weight. Not speaking a language of the country where the qualifying relative would go to counts. Community hardship and economic hardship count. Now, I want to leave plenty of time for questions, so let's go to the persecution waiver. Again, you can apply anytime during training. Same thing, unless it's granted, J-1 sponsorship will continue if it's pending or denied. If it's approved, you may finish out your current J-1 program, but ECFMG will not continue sponsorship. For a persecution waiver, you do not need any relatives, only for persecution if you return to your home country. What is your home country? That comes up a lot. It's the country which issued the certificate of need for you as a J-1, and it would be generally listed on the DS 2019 as country of last residence. So an easy example would be if you're a physician who's a citizen of Austria, but your certificate of need came from Iran, then you would prove persecution in Iran and need not worry about Syria. You may file both hardship and persecution waivers simultaneously, and many times we do if there's a qualifying relative. You can also have an interested government agency waiver, Conrad 30, or federal agency waiver pending at the same time as you do hardship and or persecution. You may not have two interested government agency waivers pending, more than one at the same time, but you can with hardship and persecution.
So that's three separate buckets of waivers. The interested government authority, i.e.,
Agent state 30 or yeah.
right, or the alphabet soup of federal governments, IGA. Then you have hardship to a qualifying US relative, or you have persecution of the actual individual themselves going home. And you may have one in each maximum.
Yes.
You cannot, you could have a total of three, one in each, but
Yes, you can. You could have three.
you could not drop more than one inside an IGA. You can only have
No,
one inside an
right.
IGA.
You can't do two state 30s or a Appalachian Regional Commission and state 30.
And there's an affidavit you have to sign in order to demonstrate that you've
Absolutely.
only done one IGA. Okay.
All right. For persecution waivers, next. Same process for persecution waiver. The I-612 is filed with USCIS and sent. If it's approved for recommendation by USCIS, it goes to the waiver review division of the Department of State where they make the final decision. Next. All right, now it's time for your questions and answers. As I said again, we welcome all of you as clients, both you and your employers, and would be happy to help with any of your immigration questions and to consult with you. All right, can we go to the questions?
Well, going down the Q&A, we have one question saying, do you have any updates on the travel ban?
It's coming in very soon. So don't travel. And if don't travel, period. It could come into effect while you're traveling. For those of you who remember the travel ban of 2017, it was pretty much of a horror show and very stressful for all the clients who didn't know if they were going to get here and all the nonsense. So, I think you probably have all seen the New York Times. Somebody leaked to the New York Times a list of countries which were purportedly going to be on the list and different levels of risk. Next question.
Are there any exceptions for citizens of Bermuda?
Not for waivers.
Not for
No,
waivers.
there's an exception for sort of a tourist visa situation.
Here's an interesting question. Does being married to a US citizen help with the waiver process?
Beautiful question. You still need the waiver. If you're married to a US citizen, you may qualify for a hardship waiver.
The one that needs the qualifying relative in the US.
The qualifying relative, yes.
But yeah, it is merely marrying a US citizen does not exempt you from the waiver if you had to get one in the first place.
But
Yeah.
exactly, you'll either need a Conrad 30 or federal government agency, a hardship or persecution waiver. It does not waive your waiver. You have to get a separate one.
How would the J-1 and the waiver requirements apply for somebody who did a 3-year residency in a VA hospital and then 1 year of fellowship in a county hospital?
With respect to what?
That's a good question. The question did not ask. So
What do,
is
oh, say the question again.
would this apply for someone who did a 3-year residency in a VA hospital and then 1 year of fellowship in a county hospital?
I'm going to guess if the person wants to uh, annotate their supplement it, I think you're talking about a physician national interest petition where you have to serve a total of 5 years in medically underserved area or areas. Doesn't have to be the same area, but they all have to be underserved. However, smart question there. All VA hospitals are considered underserved for the PNIW purposes. You may have gaps in your PNIW service. You can go off, do a residency, collect 3 years, and then go do a fellowship not in an underserved area, and then go back and do two more. There is no length of time you have. You have forever, I guess, to complete your 5 years, and you can have interruptions in the 5 years, which is a great thing for those going into fellowships because they don't often come that we have the question of, okay, I got a J-1 waiver, I did my 3 years in a medically underserved area, now I want to go to fellowship, and they will only give me a J-1. So a PNIW can be valuable for that if filed early enough in the waiting list works. So try not to go into a second J. It's very, very problematical. We can discuss, be happy to discuss with you options. We just went through a bunch, but there are others.
Next question is, can one remain in the US while waiting for the PNIW if they do not have an approval for a J-1 waiver?
No, until what? It was 2023 when there started being a backlog in the EB2 immigrant visa category. So actually, we used to do that, but right now, all you can file is the employment-based EB2 I-140 self-petition. You can't file the accompanying green card application unless your priority date is current. Right now, it's about 2 years behind. When it catches up, you can, but you can't wait here with just the I-140. So we need to look for other options. Of course, there's always the O1. We didn't go into that because you all basically know it's
Right.
available.
But you do not need a J-1 waiver in order to be employed under non-immigrant categories.
What do you mean?
So if you wanted to do an O1, then you can do that.
O1, you want to go O1, but be careful about the O1. I may have psychologically left it out because I don't they often O1, the disadvantage for an O1 is that often employers think you just ask for them like you do for an H, which has totally objective criteria. You're an MD and you got a license, period. You get an H1, right? For an O1, you have to prove your extraordinary ability, and they're not automatic, although I have to say USCIS has been quite generous with doctors.
Mm.
But I often call the O1 as a bridge to an infinite bridge to nowhere. This happens very often with our wonderful physicians in New York City. They love New York City. They love their jobs. They love their bosses. Waivers are extremely hard to come by in New York. They get usually twice as many applications for their 30 slots as, and so half of you at least are not going to get a waiver. So you love your job. You say, okay, I'll do an O1. They say, okay, we do an O1. What happens then? Well, it's not anything evil on the part of the employer. They just need more doctors. So they say, okay, you don't need a waiver, so we're not going to submit a waiver for you this year. You've got 3 years on your O1. Then you got more and more, and the O1 goes on. I think our record was a doctor on an O1 for 14 years before she finally got a J-1 waiver. So we try to avoid that, but it's a very common request for people in New York where the state 30 is so oversubscribed in other areas. Next question.
So the next question is a little bit specific, and before we address it, I just want to mention that we don't comment on individual cases. But I think this one has several details that are very interesting, could be helpful.
Okay.
So we have a state Conrad 30. It's
Uh-huh.
approved. The waiver's been approved.
Mm-hmm.
State packet was sent to DOS in
Right.
February. The
Right.
DOS is now asking for it to be resent again because they can't locate the documents. First of all, is that common? Have you seen that before?
Very common.
Okay.
Um,
And
so I assume your attorney will get in touch. Now, one thing about that is greatly improved on waivers is that they're all being emailed from the waiver agency, State 30 or SCRC or whatever, to the State Department.
Mm.
And that saved weeks, if not months, in many cases, the emailing system. Now that they're emailing them, you say, how can they lose them? I don't know how they can lose them. But yes, everybody, all like the attorneys I sent, we have a very robust group called the International Medical Graduates Task Force, where we daily show, post information. There are many. And the thing for the agency to do is to resend it. And as whenever we've had to do it, they've been super cooperative.
So one option that
Perhaps it's because I threatened to hand deliver them or something. So, oh, we don't want her at our door. Email it again. Yeah, on
now,
the second emailing, they usually get it.
now this person asks because they have no boards to help them extend for a little bit further. What are the options if the DOS's favorable recommendation is not out in time? Could they consider a change of status? And
Great question.
does the fact that they have an LPR, that is to say, a green card holding spouse, help them?
Green card spouse won't help if you've still got to do your waiver. If your waiver is delayed, and I really recommend not really, really, unless it's absolutely necessary, don't leave the country and go wait. We had a client last year who had to leave because the employer didn't make the offer until the last minute, and it would add about a year for whatever reason. So, status to stay in. First of all, remember that you have a 30-day grace period after the last day on your J-1 program. So you may file to change the status from J-1 to H-1 until 30 within, as long as you file within the 30-day grace period, it is fine and you're authorized to remain here while it's adjudicated. Now, we have also had instances where there have been delays in issuing licenses, and you're supposed to have a license to file the H-1. And immigration historically has been very understanding. And if you have to file, the most important thing is filing by July 20, within the 30 days. And so if you have to do that, you can file the H-1. We don't like to do it, but we can file it without a medical license, for example, if that's the holdup, whatever the holdup is. Uh, and then immigration will issue a request for evidence to provide the license. They've been good about that. They do have the right to deny it, so let's keep the error we're in mind, but they do have the right to deny, but generally don't. Uh, and also note that you may file your change of status petition to H-1 if you can get a screenshot from the Department of State website saying that they have recommended your waiver to USCIS. And the lawyer can coordinate between the various offices of USCIS and get the waiver approved and then the H approved.
So that is to say, the electronic online notice of
Yeah,
approval
yeah.
is fine. You don't need the actual paper approval if you haven't received it yet. So that buys a few days of mailing time.
Actually, they don't give paper approvals. And by the way, the State Department sends all their approvals out by email now and attaches the paper to the email. So you're not going to get anything in your mailbox, which is a good thing.
Follow-up question is, or the following question, there's one inquirer who has a J-1 visa that expires and their residency finishes in June 26. That is to say June 2026. Now, an extension was refused because there's a hardship application pending. So have you heard of this happening?
No, pending or approved. Can this person add to
Right.
their chat?
So
Yeah.
we would have to a
No,
couple of
but
extra details for
a
that.
couple of words about ECFMG. They're not the ECFMG we used to know and love and interacted with the J-1 physicians, interacted with attorneys. They have in recent years come up with new rules in the middle of everything, ruining people's lives. Yes, that is a criticism of ECFMG leadership. It is not what it was. We don't have the give and take. They just say something arbitrary. So could this person put in the chat box whether more
They just
effect.
followed up to say it is pending. So the hardship waiver is pending. Is this a deviation from the norm
Yep.
administratively?
Yes.
Okay. So
And to be concerned about clearly.
at this point, speak with a lawyer directly. Jan Pederson is such a lawyer.
Well, they probably have a
Right.
lawyer. Speak to a lawyer. We can deal with it. But that's that. Thank you for sharing that. I will share it with my 100 lawyers in our task force and indicate that the extension for from 25 to 26 was denied because you have a hardship waiver pending.
For the
And if you're sure it's not proof, say so. I'm going to put that out there, and if the person wants to email, I'll see if anybody else has had that happen.
The next question, for the PNIW, the Physician
Mm-hmm.
National Interest Waiver, do you still need to complete a J-1 waiver?
Great question, comes up all the time. Yes, they're two separate things. The J-1 waiver waives the requirement that you go bye-bye for 2 years. The PNIW is the ticket to a green card. It's an immigrant visa petition. And so the way that it relates is if you do 3 years in an underserved area on your J-1, that counts towards the 5 years for the PNIW green card. Also, another thing is you may pursue, and many of our doctors do, both PNIW and green card through perm employment sponsorship by the employer, particularly well, in situations where you're not born in India. In India, PNIW, if you're born in India, PNIW, since it's going to probably take 5 years to get your green card anyway, you don't lose anything by doing your 5 years in an underserved area, basically. And of course, a lot of you are trying to graduate file NIW petitions under the employment-based second preference exceptional ability and EB1A extraordinary ability. We also do those petitions. We like to be conservative and give you the best chance of not getting an RFE or an approval. I should say that the approval rates for both NIWs, EB2s, exceptional ability, and EB1A extraordinary ability have gone up in the last couple of years, not even before the new administration. And everybody's reporting more requests for evidence on EB1As and EB2s. Now, I'm not attributing that to any new change in policy in the government. In fact, under the last administration, they liberalized the requirements for both EB1 extraordinary ability and EB2, which, as you know are both self petitions. What I attribute it to is the nature of humanity. Since both are self petitions and both accord a big measure of independence, people are flocking to them. And people are flocking to them if their employment is uncertain. And there are a lot of lawyers filing really bad cases, which
Hmm.
hurts all of you who would not file bad or weak cases.
And so that is to say, clarify, RFE rates, that is say request for further evidence rates and denials have gone up over the past 2 years.
More, yeah,
Okay,
yeah.
so that's good to know.
And we attribute the immigration bar as a whole attributes it to a lot of bad cases being
Mhm.
filed. So we all suffer.
Can a candidate start their PNIW process during their residency on J-1 as soon as they sign a job? Can
Yes.
can they also apply for a Conrad 30 waiver afterwards with that pending PNIW?
Great. Boy, you folks are really educated here. Yes, you may do both.
Now, does that Conrad 30 require a 5-year contract as well?
Well, no, but you can, not for the waiver, but you can amend the Conrad contract and use it for both purposes.
Right. So the Conrad 30 needs to be 3 years in order to satisfy the J-1
Right.
waiver. And if it is 5 years, it also satisfies the
The
PNIW.
three of the
But
five, yes.
but the PNIW itself can be accomplished at different locations and even with a break in between, say for the
Yes,
fellowship.
yes.
Right. All right.
Next.
Next question, and we're down to our last few.
Uh,
If a person's not able to get a J-1 waiver, but their employer does file an O-1 visa with premium processing, then do they need to leave the country for the official change of status from J1 to O1?
Absolutely. That's a
So
quick one. Yes.
they need to leave.
and get a visa.
Mhm.
So be careful about that, depending on your country, Um, we had a call from a client a couple weeks ago who the employer said, just leave and go to Pakistan and get a visa. I'm not sending a male to Pakistan to get a visa. We ended up arranging for him to go to Mexico and get a visa, but I was astounded that they say, just get on a plane and like there would be no problem in
Mhm.
Pakistan.
And there are certain visa consular posts that are very experienced in processing physician visas inside the US, and which you would consider more sympathetic.
Right. And also you got to consider the travel ban now. You got to
Mhm.
factor in that. And remember, sometimes I can hear from doctors that think that if you get a change of status from J to H, you have to leave and go get a visa. You do not have to leave and go get a visa. I mean, there are exceptions where you've been out of status, but not.
Mhm.
Not
Next,
if you've been in status, you can change. You don't have to travel anywhere. I've seen so many people who actually think you have to go out and get a visa.
we'll try to cram a few more questions in. How does one get employment authorization after being approved for a hardship waiver?
Hardship waiver only excuses your 2 years. It is not employment authorization. So you go to a visa status which would allow it, such as an H, or if you're married to a citizen or a permanent resident with a priority date that's current, then you would get it through a green card application. Did I answer the question?
I think so.
Okay.
Yes. Um,
Next.
we're skipping ahead a couple to more
Sure.
general questions. So if somebody's finishing Conrad 30 and they're looking at other jobs, is it too late to have an extension with another employer?
No, no. I mean, you have to file for an extension before the last day of your current H-1 employment or within 60 days from the termination of job one until employer two files your H-1 petition, not approved, but files the H-1 petition.
Okay.
And then if you're in status, if you file within the 60 days to go from employer A to B, you can also start work for employer B before the petition is approved. It's called porting.
That's the AC-21 porting
Porting,
process,
yes.
yes. And so in this case, would a plan to self-sponsor on a PNIW and premium process it, try to get an approval ASAP, would that be feasible? They're considering, let's say, a 2-year contract in an underserved area to complete their 5 years of PNIW.
Repeat that, please.
Plan on self-supported PNIW with I-40 application this month with premium processing on a 2-year contract at an underserved area to complete 5-year requirement.
That's fine.
Well, you heard it from here. Fine. Let's see. There's one last question that crops up every so often, and this
Yes.
might go beyond professionalism and might go beyond immigration law. If someone gets a J-1 and their spouse gets a J-2, their spouse is therefore also able to work. Does that spouse have to live in the same household as a J-1? And do they have to work in the same state, or could they go somewhere
Well,
else in the
there's some
US?
sense at ECFMG that you have to live in the same place, which I think is completely illegal.
So
And one other status you might option consider is flipping if one spouse is J1 and one in J2, they might consider flipping J1. The,
to the other spouse.
yeah, flipping, yeah, that's allowed.
Okay. Well, we are all out of time, unfortunately. We got about halfway through the questions, and I do apologize for not getting around to the rest of
I'll
them.
answer two more.
We'll go for two more. All right.
Okay.
Could you please talk about the Health and Human Services waiver and how many years of O1 can a person apply for on that?
I I have to know whether it was research or clinical. Well, clinic research waivers take about 4 years. The clinical J1 waiver takes a month or two. And the other part of the question,
How many years of O1 can a person apply
oh,
for?
forever and ever. It's initially, thank you for the question. It's initially approved for 3 years, extendable in 1 year increments. However, you can extend in 3 year increments after the first 3 years if there's a material change in job duties.
Is there a place online where a physician can look up the Conrad status of the states to see whether or not they filled all of their 30 spots this
A
year?
lot of states publish them online on their own state website. We looked up what we could find for last year, and your usual suspects are there that didn't fill their slots. California had a couple left over, amazingly enough. Colorado had plenty. District of Columbia desperately needs you. They only used 10 waivers last year. Idaho 1, Hawaii 14. Nebraska has plenty left over. North Carolina, North Dakota, Rhode Island, South Dakota, Tennessee. Washington State had a few left over, and Wyoming. So as far as that goes, it's kind of a state by state thing, or ask your attorney. We generally know and can find out. Um, but remember, federal waivers first, open year round, unlimited in number. So
And,
that was a big boom to everybody that wanted to work in Florida, because Florida always ran out of its 30 waivers. So now it's wide open.
and some states will even require you to have, they might even push your case away if there's a
There's some
federal.
states who will not process a state 30 waiver if you're eligible for a federal waiver. We don't like those states, but you should have a choice, an intelligent choice. So, tell the lawyer should not be wasting precious state 30 slots if they can use a federal program, generally speaking.
Okay. And a final question is a logistical question
Yes,
for those who might not have caught the start end of this broadcast. Is it
yes,
being recorded and can they view it online?
yes. It will be on YouTube and a podcast, and we will send the information out to everyone. And we welcome your follow-up questions. I apologize if we didn't get to them. Be strong, be courageous, and keep your lawyer's number memorized in your head or written on your wrist, or make sure that your lawyer's phone number doesn't look like a tattoo, though.
Right, right. All
Thank
right.
you all for
Thank you all
coming
very
and
much.
taking the time. It's been fantastic being with you.
Thank you. And we look
Take
forward
it.
to other ways of helping you continue to contribute to the medical wellness of American patients. Take care. Have a great
Thank
week.
you. Bye-bye.
Bye bye.